The special tribunal has dismissed an application by businessman Hamilton Ndlovu to stop further legal action against him by the SIU. Now, the Special Investigating Unit and the National Health Laboratory Services are trying to recoup some 172 million rand from the businessman, which he's alleged to have received through fraudulently awarded tenders to supply personal protective equipment during the pandemic. Now, you may recall Ndlovu first made public headlines. This was around May last year after video was posted online of him boasting about his luxury fleet of vehicles worth about 11 million rand. To talk more about this, then we're joined tonight by the Special Tribunal spokesperson, Salbi Makgoto. Mr. Makgoto, a very good evening to you. Thank you so much. Welcome to the program. So what does this outcome today mean for the process of the SIU pursuing a review? Can it start immediately?
Thank you very much. Good evening, Tembekile. Good evening to the viewers, and indeed it's an honor to be here. What this means, the outcome of the stay application today primarily means that now we have cleared the path for the review application that has been instituted by the Special Investigating Unit and the National Health Laboratory Services. That review application is scheduled to be heard in March of 2022. This stay application was filed at the Special Tribunal sometime last month, wherein Mr. Ndlovu wanted the Special Tribunal to put on hold the proceedings in view of the fact that he still has another litigation battle to mount at the South African High Court to fight the preservation order by the South African Revenue Services. So the judge who presided on the matter today, Judge Lebogang Modiba, has dismissed the application with cost and ordered Mr. Ndlovu to file the necessary papers to enable the Special Tribunal to finalize the matter expeditiously as scheduled for March next year.
And Salbi, does Hamilton Ndlovu have any other recourse, or does he simply have to accept this then and go with the judgment out today?
Well, at the moment, he does not. Remember, we have already granted the interim preservation order. As we speak, at the Special Tribunal, an amount of 42 million has been preserved. All along, we're busy with the case management in preparation of the review application. And just in the middle of the preparations for the review application, Mr. Ndlovu informally informed us that he does not have money to fight off the litigation in the review application. That was not accepted. He was ordered to do so. There was no judicial determination, and as such, he was so advised to bring in an application for the stay of proceedings. Now that the matter has been cleared, he has to prepare for the review application.
I want to touch on what you were just mentioning about disclosure. I mean, there was the issue of a lack of full disclosure of financial means, including financial resources from third parties. There's a sum of 50 million rand unaccounted for. Does that mean then that Hamilton Ndlovu lied to the tribunal?
Well, we are not yet into the merits of the case, but what I can indicate is that based on the application by the SIU and the National Health Laboratory Services in their founding affidavits before the Special Tribunal, they do indicate that Mr. Ndlovu and his business associates, who are mainly cited as the respondents in the review application, have been paid an amount of 172.7 million, of which it is alleged that an amount of 152 million flowed directly to Mr. Ndlovu for personal use. Of this amount, 103 million has been preserved by the South African Revenue Services in the order that is granted by the Gauteng High Court, and another 42 million is preserved by the Special Tribunal. But it is also alleged further that 50 million is unaccounted for, and that includes 15 million that has been withdrawn in the form of cash withdrawals and the ATMs. One of the findings that the judge made was that Mr. Ndlovu did not make full and frank and honest disclosure, because Mr. Ndlovu contested that he had third-party funding sources that were going to take care of his living expenses. But he does not go further to take the Special Tribunal into his confidence. And as such, it was rather difficult for the judge to grant an order. And as such, the point made was that it will not be in the interest of justice to grant the stay proceedings, the stay application rather, in this manner.
It's been a busy year or so of various entities in the law enforcement space dealing with cases related to corruption that's alleged to have taken place during the pandemic. How much are you seized with currently, specifically on those matters? How much are you dealing with?
We do have quite a lot, Tembekile. You are very, very correct. We had several applications early next year, as soon as the term starts in mid-January. We have had cases in the Free State, in the Northwest, and in KZN. So all these judgments have been reserved, and we do believe that as of next year, judgments will be granted. Several applications have been made. You will recall that quite recently, the applications by the Special Investigating Unit have been forthcoming. We have had several cases, especially relating to the PPE matters. We have got cases that still have to be adjudicated in Limpopo, in Mpumalanga. So we are looking at a very busy next year. Remember, we have a duty to provide expeditious litigation, and we cannot afford to waste any more time. What needs to happen is that these matters have to be decided, they have to be concluded, and appropriate, equitable, and just remedies need to be granted.
Sabima Khoto, Special Tribunal spokesperson, good to speak to you tonight, sir. Thank you very much for your time.
Likewise, thank you so much.